All right, everybody, it's 9 o'clock, so we're going to get rolling here. First up, thanks everybody for joining in. I want to really encourage you guys as we go through this to ask questions. I think that if you're thinking of it, if it's something that you're maybe a little confused about, I guarantee you there's other people. I mean, we've got 15, 16, 17 people on this looking through it. So please, please, please ask your questions. I think everybody gets more out of it. If you don't want to unmute, I'll be keeping an eye on the chat box as well. So feel free to jump in there. So let's get started. We'll see how far we get, and we'll get rolling. So purchase agreement. Obviously, especially for all you, here, I'm going to get rid of this, all of you new agents out there, the purchase agreement oftentimes is your first document that you are going to work with clients on. Typically, new agents work with buyers first before they get their listings. Not always, but so we're going to start there with the brand new 2020, and we're going to start rolling through. So, so this is the Quad City Board form. There is not a standard form for the entire state of Iowa or the standard form for the entire state of Illinois. This is the form that the Quad City Board of Realtors has put together, and it's evolved over the years. Years and years ago, it used to be a one-page, nice, easy, almost just a handshake deal. It is now a full 7 pages, and most likely in the coming years, it'll probably grow from there. So, so as you can see up here, it's just, real estate purchase agreement for the exclusive use of members of the Quad City Area Realtor Association. So it's copywritten, it's used here. There may be situations where you work with a buyer and it's a property that's listed between here and Iowa City, or here in Dubuque, or in some other market, and they may typically use a different purchase agreement. There's no requirement it has to be one purchase agreement or the other. Typically, if you feel comfortable with this is one you'll use. Sometimes they'll counter back on this form, or sometimes they'll counter back on their own form. If that's the case, let me know and we can help you with that. You can also use this with for sale by owners. Not a problem with that. Sometimes people get a little confused and say, well, they're not represented by somebody, and so they're the seller, and this is only for the Quad City Board of Realtors. You're a member, you get to use it, no problem at all. And then this last thing right here up at the top, it says, this is a legally binding contract when fully executed by all parties. Sometimes you get people who think, oh, well, I just made an offer, and so it's not binding on me, or I get 3 days to change my mind. It's not buying a used car with the lemon laws and all that stuff. Once it's executed, boom, you've got a purchase agreement. It's binding, subject to all contingencies and all those other things that are in the purchase agreement. So make sure that you're aware of that, make sure that you know that, and you communicate that right off the bat to your buyers that say, hey, if we're doing this, this is legit. I mean, there's nothing that says that the other side has to counter back. If they sign it, boom, this is legally binding. So starting out, first blank is the date agreement is written. So that is when you are making the offer. As the buyer's agent, you fill that out. This is the date that it's written. There's another place further down on page 7 in which we memorialize when the agreement is consummated, or once it's binding. Because sometimes that can be the same day. Sometimes that can be a week or two, depending on what the situation is. I do also want to mention this. I just said that while 98% of the time this is written by a buyer's agent and buyer to submit to a seller, there are some situations where you may what we call do a reverse offer. So maybe somebody has come through, maybe you took a different deal with someone else, that deal fell through, and now you want to go back to a former buyer who had showed some interest. A seller can do a reverse offer and send that over to the buyer's agent and say, hey, we're willing to do this for you guys. All right, Sherry, you got a question? Oh, she rose her hand and then she left the meeting. All right, maybe she'll jump back in a second. All right, so the next couple of lines is just putting in who the listing agent is and the office they come from. You put in the buyer's agent and the office you're associated with. You may see there's some old versions of the purchase agreement that then have people's license number put into there and those sorts of things. That at one point was done as a courtesy for the lenders out there, because as part of their SAM reports, they actually have to identify the license number of the agents that are involved with the transaction. That's kind of their reporting mechanism. All that stuff is online. They can look it up. They have their underwriters have links to those lookups real quick. So they are doing that now. We're no longer providing that. If you do, great. If you don't, no big deal. But in case you see that from time to time, that's why that was. Alrighty, next is disclosure information. And the first thing that we're talking about is agency. So it's required both in Illinois and Iowa that agency is done prior to a purchase agreement being put together, an offer being made. And so this goes over this and makes sure that everybody is on the same page of who's representing who. And it says, an agency disclosure must be made at the time a specific assistance is provided to buyer or seller. By signing below, buyer and seller confirm that prior informed written disclosure of agency representation was provided to them, that they understand said representation, and that the disclosure was provided prior to signing. Buyer and seller acknowledge and agree that, and so you choose one of these. Typically, most of the time, is the first one. The listing agent is representing the seller, and the buyer's agent is representing the buyer. Pretty straightforward. You're representing your buyer. There's another agent, either from Rule or from Foster or from whoever on the other side, and they're representing the seller. That then you would just check that one. The next, probably most common, is dual agency situation. If you have a situation where it's your listing and a buyer is going to buy your listing, you would check this one. It says, the undersigned confirm that they have previously consented to your name acting as dual agent in providing brokerage services on behalf, and specifically consent to the licensee acting as dual agent in regard to the transaction referred to in this document. And then they have to initial off on that right next to it. So this was something that kind of came to light a few years ago. We used to just sign down at the bottom, but both Illinois and Iowa, especially Illinois, want some acknowledgement from both buyer and seller next to where they mark that they know this is a dual agency situation. And so you have to do that. Now, if you're choosing this first one, there is no reason for anybody to initial the dual agency stuff here. We see it from time to time, but that's wrong. The only reason a buyer and seller would initial down here is if it's a dual agency situation. The concern is if they're initialing down here and it's not a dual agency situation, do they really understand what they're initialing? They're just like clicking, okay. So make sure that if it's here, nobody initials. If it's the second one, that both buyers, single buyer, one to buy, two to sell, type of thing, their initials there. Now, there's a couple other ones that happen from time to time. Buyer's agent is representing the buyer only. FSBO. Pretty straightforward. That's when you would click here. You would also have a for sale by owner agency disclosure, at which it's reiterated a couple of times. It says, I'm not representing you, I'm only representing my buyer, and this reiterates that. This one right here isn't used very often, but it is from time to time. The listing agent is representing the seller only. So this most often comes into the case where you've got a buyer, maybe the buyer's an attorney themselves, or they just are the smartest buyer on the face of the earth, and they don't need no stinking help, and I don't want anybody representing me, and so they believe that they're going to get a better deal because they're doing it, not an agent involved. That's fine. If it's your listing and somebody comes in and says, hey, I don't want no stinking representation, that's fine. They can go through the process. You've listed it for 7%. Guess what? You get the 7% commission, and there's nobody to share that with. So it can happen, doesn't happen very often. I get a few of them a year, and agents are always just shocked to be like, can they do that? Is that all right? Yep, no problem. If somebody wants to not have representation, it's the old attorney adage, the attorney who represents themselves as a fool for a client. That's kind of the same thing when people are trying to buy these things without having somebody assist them. So that's the agency disclosure. You got to have one of them. There's no other options. There are only 4, and it can only be one of the 4. And remember, with dual agency, you got to get their initials. But if it's not dual agency, no initials. All right.
I've got a question about dual agency.
Say that again?
I have a question about dual agency.
All right, go for it.
So I know that we need to disclose, this would be just if it was a listing agent or buyer's agent, if we have a family member that we're representing. But what if we have 2 family members, one's on the seller and one's the buyer? How does that work?
I would run away as fast as humanly possible. No, so in those situations, well, let's take a step back and then we'll get into to that issue. So agency in Illinois, it always has to be in writing. As soon as you take a buyer out and you guys are talking about any specifics, you've got to get written disclosure of agency in writing at that point. Clearly, anytime you're listing a property, you get it in writing on both sides of the river. In Iowa, you do have this verbal agency that you can provide to buyers at the beginning, but before they go in and view one of your listings, and you could be in a dual agency situation, you have to have that agency in writing before you even take them into one of your listings. Now, it gets a little bit more complicated when you get into these issues of family. So one, company policy and state law, especially in Illinois, it's very clear. If your family member is one of the people in the transaction, you cannot be a dual agent, because the law specifically says you have to treat, in a dual agency situation, you have to treat both sides absolutely equally. And to go before a judge and say, you know what, Your Honor, I treated both of these people exactly the same. My sister over here and this person who called me off a sign call, and I think their name is Jim. Yes, I treated them the exact same. There is no way you're going to win that argument if things go sideways. So our policy is, if your family member is on one side of that transaction, you do not work as dual agent. To the very unbelievably unique situations, if you've got family members on both sides trying to do a deal, I think that is probably unique enough that come talk to me, talk with your manager, let's talk through that situation. Is it a contentious situation? Is it just you are facilitating, mom selling the family house to your brother and you're just kind of helping out? that's clearly a different model than situations where you've got like a one cousin and an uncle, and those two sides of the family don't like each other, and that gets into a little bit of a different issue. So let's talk about that specific issue at some point, if you don't mind. I think that might be the best way to approach that. Like I said, my first gut reaction is family member. It's tough enough with family members on one side. To have family members on both sides, if it's contentious at all, let's talk about that and figure out the best way to make sure they're represented and to make sure that you don't get pulled into something that you don't want to be a part of.
Definitely. Thank you, Mike.
Hey, no problem. Yeah, just give me a call and we can talk through it. All right, so that's agency. Anything else? Good question.
I do have a quick question. I'm sorry, Mike.
No, oh, please go, Michelle.
It's just, please forgive me. I'm brand new, so I just want to make complete sense out of this.
That's why we're here.
Up at the top, it says the listing agent is representing the seller and the buyer's agent is representing the buyer.
Yep.
Down below, it says the buyer's agent is representing the buyer only. The listing, to me, that sounds like the same thing. So to distinguish the two bottom ones, is that when you describe that they're representing themselves pretty much?
Well, yeah. So
is that how to distinguish?
Yeah. So you only get to choose one. So if you've got a situation where there's an agent on both sides, you choose this up here. If you've got a situation where there's an agent just on one side or the other, you would choose either this one for like a FSBO, or you choose this one for like an unrepresented buyer.
Okay, the top means that both are represented by an agent.
Exactly. It's just not the same agent. If it's the same agent, then
we're dual agents.
Then we do the dual agent.
Okay, perfect. Thank you.
Oh no, good clarification. I appreciate it.
Sure.
All right. Anything else on the agency portion? All right. Next is seller property disclosure. So we all know or are learning that. Well, let's read through it and we can talk about it. So it says, if this agreement is for a 1 to 4 unit residential property and required by law, seller or seller's agent must deliver a written disclosure statement to buyer prior to buyer making a written offer. By signing below, buyer confirms that buyer has or has not received and read the seller property disclosure statement, or non-applicable. So we'll start at the beginning. 1 to 4 units. If this is a sixplex or something like that, the Residential Property Disclosure Act, both in Illinois and Iowa, do not require this. If it's a commercial property with no residential units, again, isn't required. Although if it's a commercial property, this is probably not the purchase agreement you should be using. And we also have to remember that there are a number of reasons why people may be exempt from the seller property disclosure. Sometimes if it's an estate or those, that's an estate or a trust or whatever, those are the most likely reasons for that. Although in Iowa they just changed the law, and when we get through this, we're going to do disclosures in our next round of forms class, and we'll really get into the exemptions and those sorts of things. So now it goes on, it says, the seller must deliver this to the buyer prior to them writing an offer. And that's because in both Illinois and Iowa, and we'll talk about this in more detail when we get into the disclosures, but both in Illinois and Iowa, a seller, or a buyer, if they have not received this disclosure, the contract is not binding upon them until they have received the disclosure, if it's required by law. So basically, if it's a typical transaction and you're representing the seller and you guys don't bother getting a seller disclosure put together or send it over to the buyer, you sign a contract, you think you've got a binding contract, that buyer technically can call it void anytime they want up until the time that you actually get them the disclosure and they have a time to review it. So that's why our policy is, and that's why this says, provide it to them before. Provide it to them before you write the offer. That way, once it's binding, it is absolutely binding. The non-applicable is you'd click that if it was something, for whatever reason, it was exempt. You would click the non-applicable. You should, 99.999% of the time, if there is a disclosure, that the buyer has received it. Try to avoid writing any offers where you click this and say, oh, well, we're getting it later or whatever. I've just seen way too many deals then fall apart. Buyers then want to renegotiate the deal after they get the disclosure. Deals fall apart. People just get upset. Hey, why are we dinking around with this after we've already come to an agreement? If you get that done up front, then you don't have to worry about it. We'll also talk about this when we get into disclosures of situations where they filled out most of the disclosure, but they've missed a couple of questions. Best practice is always call that agent up, say, hey, I've got a buyer who's interested, and we're considering writing an offer on your place, but we noticed that question number 13 and 16 weren't answered on the disclosure. If you can provide those to us, I'm meeting with my clients at 5 o'clock today. Get it to us before then so that we can write up this offer. Because if not, I'm not sure if my people are willing to move forward without having those things answered. You will never have a seller more motivated than if they think somebody's going to be writing an offer on their place in a couple hours. They want to know how much these people are willing to offer for it. They want, they've got, hey, maybe I've got something on the hook. That's when they will do it. If you've already got a deal put together, I don't want to screw things up, so maybe my disclosure slow rolls it. Maybe I can get and not disclose it till a week or two before closing, and by that point, are they really going to renegotiate? Probably, So that's why you want all of these things done up front. So that's the disclosure. The next is lead-based paint disclosure. Again, there are some exemptions to this, and we read through this as, if this agreement is for a residential property built prior to 1978, seller must provide buyer with an EPA-approved lead hazard information pamphlet, 2, a seller's lead-based paint disclosure information statement. By signing below, the buyer confirms that the buyer has or has not received and read the above described documents, or non-applicable. Non-applicable is used, it was built in 1984, so non-applicable. It was after, it was 78 or after. But if it was before that, again, make sure that those disclosures are done properly before the offer is even written and is submitted back with your buyers signing off on it as part of the offer. D, radon disclosure. So in Iowa, radon is baked into B, the seller property disclosure. It's above the signature line, and again, we'll talk about that in a few weeks. But in Illinois, it is a separate disclosure form, and it's modeled a little bit over the lead-based as the lead-based paint disclosure form is. But that's why it says for Illinois properties only, and it says by signing below, buyer confirms that buyer has or has not received and read the radon disclosure, or non-applicable. Obviously, for any Iowa properties, you just hit non-applicable. In Illinois, there are some exemptions for that as well, so you could do non-applicable for that, but the vast majority of the time, buyer has received and read the radon disclosures. The last thing here is seller and buyer requests that broker select, prepare, and complete documents allowed by law or rule, and may contact their client by telephonic or electronic communication. That seems very dated language, but that's what's there. So why is E in there? This seems pretty straightforward. I'm working with you. Of course, we're going to be signing documents, and sure, you can call me on the telephone, and this electronic communications that you speak of? Sure, that's great. Well, the reason that is in there is, if you remember from class, they talked about, the unauthorized practice of law. And most likely they kind of got into, at some point, kind of the history of that. And if they didn't, I'm going to give it to you right now. So years ago, there was a big fight between attorneys and real estate agents. And real estate agents were, helping their clients fill out purchase agreements. Like I said, the purchase agreements were like 1 page long, and then real estate agents were writing, to customize it for that particular deal, we're writing all sorts of different stuff into it. Paragraphs, language, adding stuff to it. And the attorneys were like, hey, this is getting out of control. You're now kind of stepping into our world and you're acting like an attorney. So there was this big fight. In Illinois, there was an actual lawsuit. It was the Quinn case, and basically it went up to the Supreme Court of Illinois, and the rule basically said, you know what, real estate agents, you can do this provided that the forms are provided to you by your board, that you're just helping them fill in blanks, that either the board provides it or an attorney provides it, but you're only filling in blanks, you're not writing big paragraphs and doing all those things. And there was another provision in there that says you also have to get the permission from the buyer and seller, and they have to specifically ask you to select, prepare, and complete documents. So this meets that criteria. Shortly after the Quinn case, Iowa was like, those are pretty good rules. Let's not wait for a lawsuit to happen. The Supreme Court just, and the Bar Association just said, you know what? This is our rules too. And so both Illinois and Iowa have almost identical rules on the unauthorized practice of law. Again, as long as the form is something that is provided by the board or an attorney, and you're just assisting in filling in blanks, and they've asked you to select, prepare, and complete those documents, you're good to go. Now, the question always gets begged of, what is filling in blanks? I mean, as we go on here to page 2, we've got additional conditions, and you've got, 4.5 lines here. Is that just filling in a blank, or is that unauthorized practice of law? It's kind of rested in, if you can do it in a sentence or two, you're probably okay. But that's kind of where I come in. If it's complicated, let me know. I can prepare the form, leave the blanks for you to assist your client to fill in, and you're good to go. If you find yourself writing more than a sentence or two, call me and we can help out. All right, so then the buyer and the seller sign right here. So that does our first page. Half hour into forms class, we've gone through exactly 1 page, and this is probably the simplest page we've got in the purchase agreement. So this kind of sets the stage. As you can see, there's nothing in here that talks about any of the terms or conditions or negotiable items of the purchase agreement. This is just basically the first cover page that lays out and sets up the agency information, the disclosures information, and make sure that everybody's kind of on the same page of what is included in this purchase agreement moving forward. So everybody signs this, and then we move into page 2, which we start to talk about the meat of the purchase agreement. So before we get into that, any questions on this so far? All right, well, we'll get rolling. Again, if you don't want to unmute or you don't have a microphone, you can always throw something in the chat box. I'll keep an eye on that as well. So the first thing is the blank that says seller, parentheses. What does that mean? This is just basically, who is the seller? So typically in the Quad City Board of Realtors, on the MLS sheet, they'll have a spot that says owner, and typically it only has their last name, or if it's a trust, it'd be like the Mike Wendt Trust, or sometimes it says owner of record, or something like that. So that's not really a good place to get the name of the seller. I typically, the first place I look for is on the disclosures, if there are any. Typically, if it's one seller or two seller, they fill out the disclosure forms and you have their full names are on those disclosures. That's usually where I start, but that is not where I end. I then double check with the county records. So either Rock Island County, you can look through that through the CRS information on the MLS. Same with Scott County. Scott County's records through the county website. Just make sure that the names kind of match up. If you've got something where they filled it out as Bob Papauser, and then you look it up and it says Robert Papauser on the thing. Okay, great. I'd probably put the formal name in as the seller, but make sure that those things are pretty darn close. If they're not, or there's some discrepancy, call the listing agent. Say, hey, I'm seeing this on the public records, but the disclosure's filled out by somebody else. What's going on here? And sometimes it's an issue where they bought this thing on contract and it's a contract for deed. They don't have the deed yet. That's who they're getting it from, But as a buyer, you're going to want to know that, because that could be a little hitch in the giddy up as we get the disclosures. Or, if there's some kind of issue where something hasn't been recorded at some point, you want to know that sooner than later. So I always try to match those things up. If they match, awesome. If they don't, then you want to touch base with that listing agent, or you may want to call me, or we get an attorney involved. I was talking with an agent just the other day where she had some clients that had immigrated here, and in their country, the last name came first and their first name came last. But when they came through and got their documentations in the U.S., that got flip-flopped, and they had bought a house. They were going by one order of name, but on the deed it was backwards, and so we're working through with the attorney to get that all squared away. So you could have issues like that. Always issues when people get married. Sometimes the names change. You just want to make sure that this is clear and what's going on. And again, talk with your manager, talk with me, or the attorney involved, and square it away.
So a little
Nicole.
bit off of that, if there's an LLC behind the name too, do I have to make sure when they're signing that LLC is there for both parties?
Okay, so the question, in case you guys missed it, is what if this is an LLC? So typically an LLC or any business entity will, as part of their operating agreement, will have or designate certain people who can sign on its behalf. From our standpoint, we aren't necessarily, we don't have to dive through their operating agreement to verify that this is what, if they represent that they are the person who has the authority to sign on behalf, fine. If you're representing a buyer, though, they may say, hey, no, I want to make sure that this person can sign on its behalf, or vice versa. So don't take it upon yourself that you have to be the legal sleuth that reads through the entire operating agreement and says, oh, I see in provision 9, yes, you do have authority. But I would ask the question and get them to answer in writing. Say, yep, I've got authority to sign on behalf. And if they lied to you, then, what can you do? It's fraudulent. If there's a red flag, though, get me involved, and then I will dig into that. I just don't want our agents, as a matter of course, feeling like they've got to read through trusts or read through LLCs and them decipher and give a legal opinion on it. As long as things seem to be lining up, terrific. Now, with that, though, an LLC is not a person. there has to be somebody who is designated, and they have to sign on behalf of that LLC as either the manager or a member or whatever. If they just sign their name, like if I'm signing for Went Properties, but I just sign Mike Went, well, Mike Went's now obligated to sell this property, but guess what? Mike Went doesn't own this property, but Mike Went as manager for Went Properties LLC, now it's binding. So hopefully that makes sense to everybody. As we go through some of these other things, we'll talk more about LLCs and entities and those sorts of things, because that does get a little bit interesting. You know, just because somebody says they're an owner, I always use the example of, you know, I'm an owner of Disney. I have one share of stock of Disney that we bought at something when we were down at Disney. So I'm an owner, but I sure as heck don't have authority to sign on his behalf. And so, you know, they have to have the proper designation. You know, it might be an S corp, and so that person may be the president or whatever those situations are. So, so good question. That's good.
Mike, can I make a comment here?
Sure, please do.
So from personal experience, not to do with the LLC, but I had a situation where when I purchased my house a few years ago, the seller signed on it, everything went through. But 2 years later, we go to try to refinance our home, and it turns out that the previous homeowner's ex-wife, who they had filed a quitclaim deed at the time, never got recorded. And so it turned out that the ex-wife was still on our deed. And it took us, we started it this last July, and we are just now coming to close on that refinance because of that whole process and trying to find out what we needed to do. So I highly, highly recommend double check county records to make sure that the person selling it is the person on the deed and there's nobody else there.
And that's good information. And my assumption is that's an Iowa property, right?
Yes.
Yeah. So this gets into something we'll be talking about a little bit later. Is there's a different approach in Illinois versus Iowa, title insurance versus abstracting and those sorts of things. And how Iowa approaches it is, you know, an attorney updates the abstract. They make sure they should be protecting you. They should have verified that that quitclaim deed had been recorded, and they make sure that the title is crystal clear. So that's basically on the attorney. They should have done that. In Illinois, there's a title insurance process in which they do a review. They check things like that, and if the title insurance company misses it, well, guess what? They're on the hook now. They have to pay for all of those things. They've got to get it all squared away. And if you've got any damages or whatever, then they have to pay up for that. But we'll talk about that a little bit later down the road. But that is a good point regarding checking those public records, and if anything, if there's any red flag at all, hey, wait a minute, there's two people on this deed, but only one person is signing the paperwork here. What's going on? That's great information. Then it goes on, it says the undersigned buyers, so this is your buyers. Who's buying this? Is it them individually, husband and wife, just one person? This is where step one, you need to have your people pre-approved. You got to have a good idea, is both of them buying it, or is just one of them buying it? Because there's nothing more annoying than putting a whole deal together and then finding out that you got to take one person off of the contract. Because you find out that, you know, my wife and I, Eileen and I, were making an application, we're going to buy this house, and then they find out that, you know, I never pay my bills, so my credit score is in the toilet, so they got to take me off because Eileen is the only one that's responsible enough to pay bills, and so she has to be the one who buys the property. So that's why it's so important to start that process early, because if it, you know, one to buy, two to sell, I mean, it could be just one of the two people are actually the buyers, or sometimes it's going to be both. So you want to do that, and you want it to be their proper name. Right there. And then, so the next line is, hereby offers to purchase for a total sum of, this is your purchase price. This is the thing, hey, this is the thing that everybody talks about. Now, there's lots of other terms that we'll get into, but I'm going to buy this house for, or I'm making an offer for $165,000. Now, we know through using dot loop or just even the old traditional, oftentimes, okay, well, maybe there's a counter offer and they say, no, not 165, I want 171. And so they cross out an initial and date the changes and go back and forth. But this is the top line purchase agreement. That's what commission is based off of, and that is the number right there. And then it says, the real estate located at, and that's just the address. 99% of the time, our properties have addresses. Sometimes if you're dealing with a farm or some land out in someplace, it may not have a proper address, but put down whatever, it may be Rural Route 1, Highway 150 or something like that. But most of the time you've got an address. I will say that there are a couple of weird situations in which the E911 address is different than the mailing address. I would always just put the E911 address in here, but you may run it. This happens very rarely. There's just a few situations where, just because of how the postal office works, that if you send it to their E911 address, it goes to the post office station in Rapid City, so they have to go down to the post office to get it. But if you send it to a Hampton address, they're on the end of some road, and they'll actually deliver it to their house. So there are a couple of weird situations like that. If you run into those, let me know, and we can touch base on it. But this is supposed to be the address. Now, the legal description as follows. So again, legal descriptions, in some instances, it's as easy as, lot number 7 of Sheridan Heights Edition in the city of Moline, pretty straightforward. Other times it gets super complicated. Either, it's in a subdivision and it's like the west 10 feet of this and the excludes the 15 inches of that, and, or it's a meets and bounds thing. Do your best. Put it on here. Typically the board recently changed from legal description to abbreviated property description or something like that, because a legal description is very specific and has to be done in a certain way. But what I usually put in there is I give it my best try of what I've been provided, and if it is something that is complex, I say, a full and accurate legal description shall be provided by seller's attorney by X date, or something like that. So that, and that's not very far from now. I mean, I want that legal description, sooner than later, because we have run into weird situations where, you're buying this house and it seems that you're getting this garage, but really you're not getting this garage or whatever. Now that you kind of get into surveys and to how you absolutely verify where the boundary lines are. But as far as the legal description goes, don't guess at it. That is something that needs to be very specific. If you do have the full meets and bounds, you can say, see attached as Exhibit A or whatever. If you're running into problems finding that legal description, talk with your manager, your mentor, me. We can walk you through that. But worst case scenario, you just say, the legal description to be provided by the seller's attorney by, if I was writing it today, I'd say within, 5 days of execution of this agreement. So that gives a time frame in which we're going to get it. We're going to make sure that it's right, and and maybe say, if your buyer's concerned about it, and to be approved within 2 days by the buyer or something like that. All right, that all makes sense. All right, earnest money. So traditionally or historically, the purchase agreement just said earnest money had to be delivered when you made an offer. And that was just how we used to do things all the time. Now, when we used to do things all the time, paper copies were handed to people. Oftentimes, a buyer's agent would actually present the offer to the seller with the listing agent and the seller in the room, and they'd make their presentation. I remember doing that back in the day. That does not happen very often anymore. Now it's with .loop and DocuSign and people emailing things. Oftentimes these things go back and forth, and then you get a deal together, and then you run across the river to drop off the earnest money or whatever the situation is. So that's why this has got this blank here. It says, within blank days of acceptance of this agreement, buyer shall deliver the sum of blank in the form of a check or money order to be escrowed with blank as earnest money to be applied to the purchase price at closing. Okay, so within blank amount of days. Typically you should, if you're working with your buyer, you should have that check in hand. Let the other side know, say, hey, once we get this executed, I've got this, I'll run it over, and so within 1 day, I'll have it over to you. That's the best practice, because when you start putting in like 5 days, then they're going to mail it to us, and I get calls on a regular basis of, now what do we do? We were supposed to get it in the mail. They said that they sent it, but it hasn't shown up yet. And I know the post office is behind, and there was a storm that happened, and or they put down the wrong address. So they really sent it, but now we got to wait for it to get returned. And make sure you've just got that in hand and what's going on. The amount of the earnest money, there's no requirement. You don't have to have earnest money to have a binding contract. It could be zero. But in our market, culturally, it's kind of come up. If it's less than like $100,000, most people put in like $500. If it's over $100,000, they put maybe $1,000. If it's a higher priced home, you might get into $2,000 or $3,000 there. There are some places in the country, many places, where it's just standard. You put down 3% of whatever the purchase price is. Some places it's 5% of whatever the purchase price is. I personally like to have a higher number in for the earnest money, and it does a couple of things. One, it keeps more deals together, because somebody's not going to be like, $500. What the heck? I'm just going to disappear, and then we're chasing people down trying to figure it out. Also, if the money is large enough, then if there's some real dispute, it makes sense to go to small claims and figure it out. If it's $500 and it's going to cost you $278 to file a small claims court and then serve the person, people just go, all they do is they just get mad at you, say, well, what am I supposed to do? And so I'm a proponent of having a larger earnest money, but it's not required. Like I said, it's up to what your people can afford and what the situation is. And it says for check or money order, no cash. We do not want cash. We don't want to be dealing with that. But check or money order, and to be escrowed with. Again, culturally in the Quad Cities, historically, the vast majority of time, the money was held by the listing company. Whoever had the listing, they held the earnest money. As a juxtaposition, in Galesburg, it's the exact opposite. It's always historically the buyer's company held the earnest money. So there's no law that it has to be one way or another. There's a lot of old, seasoned real estate agents that feel like, well, it has to be with the listing company, and if you don't send it to the listing company, then you're doing something wrong. You're not. That's fine. When we had the bridge issue, many people, rather than, I'm going to have to drive over to Remax River Cities to drop off the earnest money, I'm just going to hold it here so I don't have to fight the bridge traffic. That happened quite often. So you kind of get both. I would say the vast majority still is held with the listing agent, but it doesn't have to be. We also have a number of kind of newer real estate agencies that don't have the full bandwidth or the full brokerage service. They don't even hold a trust account anymore because they can't figure out the accounting apparently. So if those situations, clearly we need to hold it. I don't know how when those two discount brokerages do deals together, who's holding the earnest money for them, but I guess that's something they got to figure out. So that's the blanks with those things. And it says, to be applied towards the purchase price at closing. So clearly if you're offering $150 and you put $1,000 down, then what's left is $149. So earnest money is all about managing your client's expectations, and it is so important that they understand kind of this next paragraph. I'm not expecting you to read it verbatim to them, but I'm going to read it to you verbatim so you know exactly what's in there, but then we're going to talk about what it actually means. So then it says, broker will hold money in a special non-interest-bearing escrow account if in an Illinois property, or a special interest-bearing escrow account if an Iowa property, with the interest being forwarded to the Realtor Foundation of Iowa, a charitable nonprofit entity, or as directed and mutually agreed in writing by both buyer and seller. Okay, so Illinois, the bankers apparently were really, really good lobbyists, and they say, hey, all you real estate agents, you deposit your money with us, and we get to keep the interest, because you get none of it. Now, why would the state do something like this? Well, they don't want any incentive for a real estate company to hold on to earnest money. Because at any one time we can have, thousands, hundreds of thousands of money in earnest money, and when interest rates were 12, 18% back in the day, you could make some serious coin on just holding that money. Well, they didn't want situations where the real estate company was like, oh yeah, this is too bad that this deal didn't get to, well, maybe we should just, try to massage it. We'll try to work it out another way, and, to the detriment of the client. So they said, nope, no benefit to the real estate company. In Iowa, the lobby were the realtors but they're like, it's still not a good idea that the brokers get the money, but the Realtor Foundation gets the money. And from time to time, they donate money to our local board for like habitat houses and those sorts of things. So, I mean, it goes to charity, and it's a good thing. Now, the clients can negotiate that it goes someplace else. They can say, hey, earnest money goes in, the interest on it goes to the buyer, or the interest money goes to the seller. Interest rates have been so low recently that really just doesn't happen. Nobody's fighting over the 11 cents of interest that some of these things could maybe earn. So it's just not a big deal. But if interest rates start to creep up, that could wind up being an issue. It says, in the event of any contingency is not met by the date contained in such contingency, seller recognizes the earnest money will be returned to the buyer upon agreement in writing by both parties, and this agreement shall be void. So basically what this is saying, if we've got contingencies in here, it's subject to my financing, I can't get my financing, we know that the earnest money, if that is the true and accurate case, the earnest money should go to the buyer. It says, in the event of a default by the buyer hereunder, the earnest money shall be paid to the seller, provided in paragraph 18, and we'll talk about that eventually, but I'm not going to open that can of worms quite yet. So basically, if a contingency isn't met, the money goes back to the buyer. If the buyer defaults, the money goes to the seller. Well, sometimes there's arguments of the buyer saying, hey, I didn't meet a contingency, and the seller saying, well, you didn't meet the contingency because you defaulted. Like financing, well, because you didn't apply for financing, or you never gave them your pay stubs. So eventually, yes, but you weren't acting in good faith and moving in the direction. So you know what? The contingency wasn't met, but it was because of your actions, so you're in default, so I should get the money. So you can see how in certain circumstances there could be a fight over this. And that's why this next line comes in and why it's bold. It says, earnest money will not automatically be returned or paid to any party. So even though it says all over this purchase agreement, and the earnest money or the contract shall be null and void and the earnest money returned to the buyer. Well, that's if those facts are true. And so sometimes you have to go to court to determine that, of saying, hey, if all these things happen, then the buyer gets it. But if the buyer didn't do what they were supposed to do, then the seller gets it. It says, in the event of any dispute as to the retention or return of earnest money, the escrow agent shall only take such action with respect to the earnest money as agreed in writing by the parties. So for earnest money to be released, one of three things has to happen. One is the deal goes through. We use it as a credit for the buyer towards their purchase price. Great. It's taken out of the escrow account and used for that. Two, the parties agree in writing. Yes, we both cancel this contract, and we're going to give the earnest money to the buyer, 100% of it, and the contract's terminated. Terrific. Both sign off on it. Or we're going to sign off on it, and the money's going to go to the seller. Or we're going to split the baby. Half's going to go to the buyer, half's going to go to the seller. As long as we have something in writing executed by both parties, then we can release. So that is option one. Where the earnest money should go in writing by the parties. Next is as ordered by a court of competent jurisdiction. So if they can't agree to it, this is where you might go to small claims court. Small claims court, they would say, you present, hey, I should get it because of X. The other side would say, I should get it because of Y, and the judge would make a determination, and then they would do an order that says, hey, rule, give the money to the seller or give the money to the buyer. And the courts could at that point say, and Mr. Seller, you owe court costs and filing fees to the buyer. Now, they don't have to do that, but that could happen. It says, and then there's a final option here that says, or pursuant to Iowa Administrative Code or Illinois Code Section 225 ILCS 454, blah, blah, blah. So basically what that says is, in those weird situations where maybe a buyer just disappears. So this happens occasionally. A buyer shows up, makes an offer, and then all of a sudden ghosts us. They clearly have defaulted. They've run off into the ether. Maybe they went to Vegas. Siegfried and Roy are both gone now, so they said, hey, here's my opportunity. That's what I'm going to do. Nobody can serve them. Nobody knows where they're at, so you can't take it to court. They clearly haven't signed any agreement of what to do with the earnest money. There are some provisions in those unique situations, or maybe somebody just, this was house, we were going to sell it as a short sale. They just decided to walk away from the property and they disappeared. Some of those things. There are some provisions that we can work through, but you need to talk with me that we can return it if the other side completely disappears. If we know where they are and they're still disputing how the money should be returned, those provisions in the administrative code or the Illinois ILCS don't apply. And then the final line here is, seller and buyer agree to indemnify, defend, and hold harmless the escrow agent from and against any and all liabilities and claims arising out of duties as escrow agent. That's a really important sentence for me because sometimes I will get a call from a buyer that says, you have my money and we're going to sue you if you don't give it to us tomorrow, And I'm like, we're acting under the law. We're doing exactly what we're supposed to be doing, and you've indemnified us and hold us harmless as long as we're following the law. So you can be upset, but go after the seller, not us. The other, I guess, reason that this is set up, we never, whoops, sorry about that. We never make a decision on where earnest money goes. We're not the judge. We're not the jury. We can't make any decisions. And the reason this makes sense, again, go back to back in the day. If you figure up in Chicago, if I was a real estate company and I'm holding earnest money and there winds up being a dispute, I will, if there weren't these rules in place, 10 out of 10 times, I'm going to give the earnest money to my client, because guess what? This seller and that seller's agent, there's a good chance I may never see them ever again. There's, tens of thousands of real estate agents and all sorts of things going on. So I would always just give it to my client. And so because of that, the state stepped in and said, hey, these are the rules, and we got to follow it very, very specifically. And that's how that goes. All righty. Well, wow, we've already hit an hour. That was great. Next Friday, we'll do this at 9 o'clock. We'll start to talk about the financing. And then as a little bit of a homework assignment for all you guys, if you can, come back with a unique term that you might put down on the bottom of page 2. It says, in addition, the sale and purchase of the property shall be subject to the following terms and condition. Bring us some kind of unique one, either that you've seen, heard, just kind of thought of off the top of your head, and we'll kind of talk through those next week after we get through the financing contingency. So thank you guys all. I'm going to try to always keep it to just to an hour, and we will start with the purchase price and the financing next week at 9 o'clock. Thank you very much. I am recording this, so we should also get this posted and be on Rule Connect and on Google Drive for you guys as well. So take care and have a good one.